Hi, everyone. Harry here to talk about the first action in the various district courts in the wake of the Supreme Court's ruling on the birthright citizenship case, which, recall, didn't go off on the merits, rather said courts can't impose nationwide injunctions except, I'll get back to that except in a moment, and then left it to the individual district courts to consider the claims on the merits with the tangible prospect that the Trump administration could just go shopping all over the country, get a bad decision here, bad decision there, and bad decision in the third place, and find another forum which, if it would rule for them on its birthright citizenship claim, namely that children of people here illegally are not citizens under the 14th Amendment, even though the amendment seems to say clearly that they are, that the Trump administration could go running with that inconsistent result in that particular district. All right. In the immediate wake of that decision, you had a case filed by the ACLU as a class action, because you may recall in the actual body of the opinion, there's some suggestion that a class action could get around the court's ruling, and commentary has been rife on that very theory. So the idea is the court says a district court can only give such relief as is necessary to provide complete relief to the plaintiffs. But if the plaintiffs are basically everybody in the country who could be subject to this new order, depriving them of the clear constitutional command, then that would in effect give nearly as broad, in some ways, nearly as broad a avenue of relief, because the whole class, if the district court accepts it, would be entitled to that relief. And that's indeed what happened. We had a district judge, Joseph LaPlante, a appointee, I believe, a Bush appointee, who really gave this very little sweat and said had already had the issue, but not in a class action, very quickly said plaintiffs get a motion for a class-wide preliminary injunction, and that applies to the whole class. Who is the class? It's children born after the effective date of the order, which Trump issued the very first day in office. So as of February 19th, if they're born, the text of the order would purport to say that even though the 14th Amendment says anyone born here is a citizen, they are not, based on a very exotic, far-fetched interpretation of the 14th Amendment that pretty much everyone thinks is not going to fly, even in the U.S. Supreme Court. But the question has been, what happens between now and then when the court gets it? And now we have the initial answer, which pleases plaintiffs. So the ACLU came in. They have 4 different plaintiffs who are, the children have been born or are expected, but we're talking about newborns after February 19th. And they stated a motion for a class. Everybody liked them. Indeed, they even tried to say, and their parents as well. And the judge declined to put the parents in the class, but he said, yes, I'm granting a class, and it's a preliminary class. This is now a sort of whole separate category in the law that grows out of the nationwide injunction case. The judge is granting a preliminary class for purposes of temporary relief. So he recognizes this class not by going through the 4 hoops in Federal Civil Procedure 23, which could come up in the future, but rather by just doing it more informally, but saying good enough for me to enter a preliminary injunction. I recognize this class, and the injunction that I enter forbidding the administration from enforcing this order, which they are very likely to lose because they're wrong on the law. And then in addition, the irreparable injury and the other factors are all in the plaintiff's favor, I'm going to grant that relief. So this was what was sort of set up by the Supreme Court decision. And notice the Supreme Court is definitely focused on this. Justice Alito specifically said in his opinion, now district courts don't try to get around this with class actions. So it's going to engender a subsidiary new fight at some point in the Supreme Court about this class action strategy. But for now, there's nothing that runs afoul of the court's order in the nationwide injunction case. So this is the strategy that survives the holding by the Supreme Court. You can't take one person, and once you've given that one person who's in front of you complete relief, you have to stop. You can't continue and give relief to the whole nation. But that's what class actions are for. And so now it's the same holding in a sense, except to give complete relief to all the plaintiffs, which is this class of people in the country who would otherwise be affected by the order. That's what class actions are for. And these are a special variant of class actions, sort of temporary ones that the court recognizes for this purpose. So first round out of the box to challengers to the ACLU, to people who want to say, we can get around the nationwide injunction ban, and who say, and most courts, maybe all, will say on the merits, this is an easy lift. The 14th Amendment argument by the administration is all wet. But this will continue to play out. So this very case probably now goes up to the First Circuit, is the court above New Hampshire, and the Supreme Court at some point. They will weigh in on this strategy to forge an exception to what they've done and thereby permit very wide relief, nationwide, as it were. So as of now, the law is this class has been recognized and the administration can't do anything. Look for it to try to push the point in an appeal, an emergency appeal, and go to the Supreme Court. But the idea, there were a couple floating around, but this main one of let's try the class action strategy has been tried right after the opinion, and the first round successfully, the judge has said, your claim is good, and moreover, I'm recognizing this whole class for purposes of relief. So at least to those who were worried, come on, this is the craziest opinion on the merits ever, the executive order that tries to undo the 14th Amendment. We have a solid statement on the merits by this judge and also on the remedy by taking the class action route, which we will see if it holds up. For now, that case can not only go up, but it's possible, likely, we'll see other cases brought in other districts. That's the upshot of the Supreme Court ruling. But what is teed up by this case in particular is the strategy of using a class action, a provisional class action, to forge an exception to a workaround of the Supreme Court's nationwide injunction decision. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.